Can you write your own will in Florida? Yes, you can, but let me show you where that often falls apart. One, Florida does not require a lawyer to draw up a will. You are allowed to do this yourself, but Florida does require that the document be executed exactly right. We call that strict constructions. That's oftentimes where the do it yourself versions fail. Not necessarily the language, but the execution and signing part of it. So, to have a valid will in Florida, the testator who's signing the will must do so at the end in front of two witnesses who are present. And those two witnesses sign in front of the testator and in front of each other, essentially everyone in the same room at the same time. If you miss a step, if something isn't done properly, the entire will can fail entirely, regardless of what it says inside. You also want to have what's called a self proving affidavit in addition to what I just mentioned. With one, the entire will be deemed self prove and admitted into court without having to have extra witness testimony. If you don't go that step, those witnesses are going to have to testify or swear that the execution actually took place the way it should, and that's not always feasible. And then within the will itself, there's a lot of confusion about certain terminology. There are Latin phrases like per stirpes and per capita that are oftentimes messed up. Sometimes we see conflicting wishes or gaps in somebody's planning. They fail to name the right individuals to inherit or the right people to help out as being the executor or people who don't qualify. And that just leads to trouble down the road. So the form is the cheap part, but the advice and the expertise for some of life's most important decisions are usually worth contacting a lawyer. So if you need any help with that kind of thing, feel free to let us know.